And we're here today asking for a reduction of your son's bond. Is there a certain amount that you think that you would be able to afford?
I mean, I don't really have a lot like to say, maybe 500. I don't really have much. I mean,
Hear me, yo. Watching how them opera boys get sentenced. You know how the fuck's going on, man. Y'all boys tuned into that Oouchie court watch. Well, we taking it straight from the jail cell to the judge. Hear me?
Hey, Judge.
Yes. Yes.
We did look at the motions that are filed, and we were not able to come to an agreement.
All right. So if you all want to have a hearing on it, I'll have a hearing on it.
Okay.
So is that what you all are requesting?
Yeah, just oral argument, Judge.
All right, so would you pull the file on Cody Salazar and see if you can find the defendant's motion for a bond?
yes.
And then after this case, I'll take up Tony Niera. State, did you have a chance to review defense counsel's motion under 32.01? It is a drug case. I think it's off docket. Let me give you the cause number. It's NITMAG number 747949. And defense, if you have a copy of your motion, if you could tender it to the state. If you do not, I can give them this one.
It's the only copy I had.
Ah. Oh, no problem. Counsel, if you give them this one and then
Yes, ma'am.
just return it to me because that's the only one I have.
Yes.
All right, thank you. And then after Niera, it's gonna be Castillo. Mr. Salazar, if you'll come down. No. All right, so Mr. Salazar, I'm in receipt of the motion that you filed. What I can tell you is unless there's an exception, PR bonds based upon the legislature and the rules they pass and the laws they pass, PR bonds are not given for violent offenses. And because this is an aggravated assault with a deadly weapon, you're not going to be able to receive a PR bond from the court unless there's some exception that your attorney wishes to present to the court. So with that being said, the court is calling, let me find you, 2024 CR 009128, State versus Cody Salazar. Can I have parties announced for the record for the state?
Ashley Jones for the state.
Defense.
Robert Gear for defendant Cody Salazar, Judge. We're ready.
And are you Mr. Salazar?
Yes, ma'am.
All right, and defense, are you adopting your client's motion to set, well, it's a motion to grant a personal bond. Are you adopting that motion?
Yes, Judge, we'll adopt that motion and we'd like to argue, if not for a PR bond, for a reduction in bond as well.
All right, so state, the motion that the defense counsel is adopting is a motion requesting a personal bond. That's it. It's not a motion for a bond reduction. So any objection to defense counsel amending his client's motion and requesting a bond reduction?
No, Your Honor, and I will state for the record that there were a couple motions filed. I do believe one of the ones the defendant filed was a motion for a reduction of bond.
All right, do you have that motion? If you all could print that out? All right, so defense, it's your motion. You may proceed.
Yes, Judge, may it please the court. My client was arrested on or about September of last year. We've been coming to court since November. State's attorney is correct that we have been conferring at every court setting. However, we're still here in the need of more discovery in the way of CPS records. And since my client obviously he's been to court every day, but not only him, his family's been here. His mother and sisters have been very supportive of him. Bond and bail should be set in an amount that is sufficient to require or have the defendant submit to court and make all his court appearances. There is also a condition that I saw on the bond by the magistrate of a GPS with house arrest, and considering the nature of these charges and that bond condition, I believe it'd be in the best interest of society and my client and myself as representing him and being able to discuss this matter with him, that the court reduced his bond to a reasonable amount so that he can bond out, number one, because he has been sitting there without much movement on the case because we're waiting on discovery and waiting for CPS records. Number two, it'd be easier for myself and him to communicate. Were we out, should we have to prepare for trial or any hearings or other further settings in this matter? Considering the conditions on his bond, we believe that those are adequate enough to secure himself with society and in the eyes of this court. And therefore, Judge, we'd respectfully request that the court reduce this bond to a $20,000 to $40,000 bond range, so that my client, with all the conditions that are already in effect, will move my client's constitutional rights. Thank you, Judge.
All right, so what bond are you saying he can make? And do you have any testimony to determine the bond amount that he can make?
I'd call Cody Salazar, Judge.
All right, can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand, state your name for the record.
Cody Salazar.
All right, defense, you may proceed.
Thank you, Judge. Cody, at the time of this arrest, where were you residing?
I was at my mother's.
And you've resided there for quite some time? And you have been incarcerated how long?
5 months now.
Okay, so you currently don't have any occupation, and you're not working. And if you were to be released, you'd have to look for a job because you don't have one waiting for you, correct? But your mother does work, correct? And she's had a steady job for quite some time.
Yes.
And she cannot afford a huge bond as the current bond amount. Is that 100,000? That's a little bit out of the range.
Yes, sir.
Do you believe she'd be able to afford a $20,000 or $30,000 bond?
Right now, I have to ask her. I mean, I don't know. I don't really know.
Would it be easier for her to afford in the bond in that amount than what the bond is currently set at?
Oh, yeah.
And property, other than her house, does she have any other property that she may be able to sell or get money for a bond?
I don't think so.
Okay, do you have any property that you'd be able to sell and get money for? So you're asking this court to reduce your bond to an amount that you believe that your mother would be able to afford to get you. Sorry.
All right, so we can go off the record. So what I need is, what have they done to secure a bond? How much money do they have? Do they have any money in the bank? So,
Judge, if I may,
yes.
May I call another witness?
Well, just 1 second. Any questions, State?
No, not for this witness.
All right, thank you. Yes, you may call another witness.
You're back against the corner.
Yes, can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
My name is Annette Salazar.
All right, defense.
Ms. Salazar, what is your relationship to Cody?
I'm mother to him.
And when prior to being incarcerated, where was he residing?
He was living with me.
Okay, and his bond is currently set at $100,000. Is that what have you made any inquiries or tried to get a bond in that amount, or is that above?
Yeah, that's way too, I can't afford.
And are you currently working?
Yes, sir.
And what do you do?
All right.
Where I
so-
work here? Sorry.
Yeah, just off the record for a moment. I know the witness. I think everybody knows the witness. We know where she works,
All
so
right.
you don't need to get into any of that.
Okay. And we're here today asking for a reduction of your son's bond. Um, is there a certain amount that you think that you would be able to afford?
I mean, I don't really have a lot like to say, maybe 500, I mean, I don't really have, but I mean, I can maybe take them out with 500, but I know it's not crazy, I know. But I like,
And you did hear the judge's announcement and
right,
about, a request for a PR bond is not,
right, they couldn't do it.
acceptable in this
Right,
case.
yes,
And so you think that $500 may be the maximum amount? Do you have friends or family that you could borrow any money from that may be able to assist you in getting this bond?
it would just be hard for me to pay that back, and I don't want to be in debt, I pay my bills and I try to, it's just,
Yeah, I mean, property that you didn't sell, that's unencumbered by any debt that may be able to.
No. I do not,
That's all I'm saying.
sorry.
All right. Thank you.
I'll pass it to Ms. Judge.
Any questions?
No questions.
All right, thank you so
I'm sorry.
much.
Thank you.
Thank you.
Sir.
All right, any other witnesses?
No, nothing further, Judge. We'll rest.
All right. State any witnesses or evidence?
As far as evidence, Your Honor, the state would enter in, I guess the police report, if you can give me just a moment to grab that.
Okay.
You want me to state about the state's exhibit 1?
Any objection?
Defense has reviewed it, Judge. We have no objections.
All right, let me just review this. All right, the court has read State's Exhibit number 1. The court will hear argument from both sides, defense.
Judge, based on the client situation, the fact that we've had several court hearings, and we've conferred with the state, we believe we're moving this case along. My client's been incarcerated since September. Considering the fact that we're waiting on more discovery and that there are special bond conditions put in place, we respectfully request that the court reduce his bond in the amount that he may possibly or his family may be able to afford. Thank you, Judge.
State?
Yes, Your Honor. Regarding the discovery, we did just confirm the existence of it last week as well. I'm sorry, on the
Just her.
6th.
Just her.
On February 6th, we confirmed the existence of that discovery, and we did send a subpoena out last week as soon as we found out about it. So the state is doing everything in its power to get those records as quickly as possible. On the other end, Your Honor, this is a violent offense. The facts alleged, as the court has read, are violent, and this victim is scared for her safety. Additionally, the defendant is a convicted felon. He is a repeat offender. He's got a prior conviction for in 2017. For a second-degree felony offense, and because of those two things, Your Honor, the facts of the case and his prior criminal history, the state believes that he is a danger to this complainant and to the community, and would respectfully request that the court keep the bond in place at $100,000.
You have final argument.
Judge, there are special bond conditions to ensure the safety of society and for the victim. My client and this victim have not had any communication in over 3 years. I would be going to his home under house arrest where the victim is nowhere to be around. So to argue that he may be a danger to her is inadequate at this time. Therefore, we believe that the issue here is what amount of bail is sufficient to assure his attendance in court. And therefore, we respectfully request the court lower the bond to $20,000. Thank you.
All right, and state, has the defendant ever failed to report to court and previously in other cases?
Let me double check that.
All right, this is what,
I'm sorry, the only thing I have is that he was a indictment fugitive in the prior case, but
all right, and then we understand why post-indictment fugitives happen. It has
Yes, Judge.
nothing to do with his not appearing. All right, and then the court does notice that there are potential mental health issues. So you're still under oath. Have you ever been diagnosed with any type of mental health issue? Have you ever received or seen a psychiatrist?
I think at a young age I was.
Okay. All right, this is what the court is going to do. Court is going to set the bond at $85,000. There's to be no contact with the complainant and no contact with minors. There's to be full GPS, waive fees. And there's to be a referral to Center for Healthcare Services. Is there anything else from either side?
Nothing further from defense, Judge.
And I'm
Thank you.
sorry, one other thing I'm going to add, and it's based upon what I read in State's Exhibit number 1. I'm going to add regular UAs. All right, thank you.
Thank you, Judge.
Thank you,
You're welcome.
Judge.
You're welcome. Have a good one.
Oouchie color watch, we're on the scene. Truths unravel, and what does it mean? In the halls where stories clash, Oouchie court watch quick as a flash.